People of YouTube, thanks for taking some time to watch the beginning of this video. It's not exactly an easy subject to talk about, but here we go. So what you just saw in the previous two slides that I kind of had up for a while, those were the words from the judge. At the end of the trial itself, before the jury began deliberating, the defendants attempted to have the case dismissed by something called a directed verdict motion. And so you can read those previous two slides where the judge basically acknowledged that our case had merit, that it should go to the jury, and she did not grant their motions to dismiss our case. So I kind of give you this information as a backdrop, and just say, imagine that you pursue justice and you go through a lawsuit and a trial, and then during the trial, the defendant doctors, their attorneys, they employ a tactic of paying hired gun expert witness doctors to testify falsely and commit premeditated perjury, lying to and misleading the jury. And then as a result, the jury sides with the defendant doctors. This is what our experience has been. So, doesn't feel like justice. Feels like perjury and crimes in the courtroom occurred. I've got another little bit of a video here to get some help from some of the people in Hollywood. So watch this clip.
Expert witnesses are the dirty little secret of our justice system. What most of the public doesn't know is that it's legal to pay experts for their testimony. You shell out enough cash and you can get them to say just about anything.
Okay, so the content of that clip points out the insidious nature of premeditated perjury and suborned perjury, both of which are serious crimes. That clip was the work of another content creator on YouTube several years ago for what looks like a college-level project highlighting an American Bar Association model rule of professional conduct 3.3 called Candor Towards the Tribunal. I've had to learn about all of this stuff, and the ABA rules of conduct apply to all attorneys throughout the United States. As a layperson, you would think that within the legal system there are guardrails to guard against even the notion of committing crimes in the courtroom. And then even worse, to think that people are highly paid to falsify and tamper with evidence, collude, and commit these serious crimes in U.S. courtrooms. One of the guardrails you would think would block these types of crimes is swearing an oath to tell the truth, the whole truth, nothing but the truth, so help you God, under a penalty of perjury. I've learned that the swearing an oath at a deposition or at trial is just mere theatrics, and here's why. The wider public needs to be informed so they can be on guard if they're faced with being a plaintiff in a wrongful death case or medical malpractice case. My experience is that the crime of perjury at trial by defense and defense expert witnesses, the crime of suborning perjury by defense attorneys, are perhaps the only crimes in our legal system where the responsibility of the actual crime committed gets passed from the perpetrators of the crime to the victim of the crime. When plaintiffs like myself, by formal motion, place voluminous evidence before the trial court that the defense witnesses provided intentional, knowingly false testimony, and that the defense attorney suborned perjury to mislead the jury, and that the defense verdict was procured by fraud, the judge says, and this is paraphrased, the judge, well, you had the opportunity to cross-examine, correct? Plaintiff, yes, but I provided the court with detailed evidence that the defense expert witnesses committed the crime of perjury in your courtroom, and the suborning of perjury also occurred. Judge, well, you had your opportunity on cross-examination, so tough luck. The prerequisite oath by the testifying witness is not even a consideration by the trial court. The suborning of perjury by the defense attorneys isn't a consideration either. The ABA rules of professional conduct aren't a consideration, even if you bring them up or point them out. Inaction by the trial courts to face these crimes head on, effectuate these crimes as being a standard operating procedure tactic for defense attorneys and insurance companies in wrongful death medical malpractice cases. The public needs to know this. So as a result, and in effect, here's how the public should understand how the swearing-in process for defense witnesses and defense expert witnesses goes so they can be on guard. And this is paraphrased. The judge, please raise your right hand. The judge, do you solemnly swear to tell the whole truth, or the truth, the whole truth, and nothing but the truth, so help you God? The judge, under his or her breath, but if you want to lie, go for it. If the plaintiff doesn't call you out on your lie while you're on the stand, you are scot-free. So lie all you want, mislead the jury all you want. I promise you, nothing will happen to you. Don't worry. Trial courts and defense teams have worked this out. You are protected. Defense witness, I do. Defense witness under his or her breath to the judge. That's what the defense attorneys, defense team, and insurance representative told me. Lying is our strongest weapon. That's what they're paying me handsomely to do. Awesome. I'm coached, prepared, ready to commit perjury, mislead this jury, and secure a defense verdict for these doctors. Thank you, Judge, for being a facilitator in the defense's plans and your promise to shield me in the future if any claims of my perjury come up. So let me be clear. I'm not saying that the judge in our case uttered the under-the-breath words I mentioned here, but these crimes in the courtroom and the result of inaction by the trial courts make these words thunderously ring the truth about the currently functioning legal system and my own experience. In summary on this point, perjury by hired gun defense expert witnesses is protected. Suborning of defense expert witnesses perjury by defense attorneys is also protected. Conspiracy to suborn perjury by the defense and their insurance company is protected. This is not fair or just.
How do you combat this corruption within the expert community?
So a question is asked in that clip, and it seems like a lot of earnest hands went up, depicting the fact that most everyone and the wider public can understand how unfair and unjust this is, and how they would want to combat this injustice. In my case, I continue to fight, and I case is currently in the appeal process. No matter what obstacle has been put in front of me, I refuse to give up. Taught myself the various steps, court schedule, court rules, and how to research and prepare court filings, and have been handling the appeal as a pro se litigant. It's all been very challenging. Since the beginning of the appeals process, I've filed various motions, my 55-page appellate opening brief, and in the trial court I filed a 165-page motion to vacate, addressing the defense's perjury in great detail. So the perjury elements, a lot of what I've been talking about here, are well documented and are in the trial court's record, available for future use. After a year and a half into the appeals process and having filed motions and briefs as a pro se litigant, and after having received various rulings and letters from the court acknowledging that I'm handling the case as a pro se litigant, suddenly in September 2021, the appeals court made a ruling that I can now no longer handle the appeal as a pro se litigant. Throughout this year and a half, none of my filings have been rejected or sent back for corrections for not following the court's rules or missing a deadline. However, the opposing party's attorney has had one of their filings rejected and sent back for correction for not following the court's rules. The court's recent ruling and their position is that my mom's estate is an entity, and I can't represent an entity as a pro se litigant. But the court itself can't cite specific statutes and only rely on a single unpublished opinion that doesn't match my exact circumstances. The court's ruling is requiring that I hire an appellate attorney, or else the court will dismiss the appeal for the estate. This is really strange, since establishing an estate and appointing a personal representative is required in order to file a wrongful death medical malpractice case. I'm my mom's duly appointed personal representative in the probate court. I filed briefs opposing the appeals court's ruling, citing relevant statutes in a very relevant Tennessee Supreme Court case, and that I should be able to continue handling the case as a pro se litigant. My opposition to the ruling is currently under review by the entire panel of judges in the appeals court. This court's ruling just seems very unfair, as if this is an effort to silence my mom's voice. I prepared this video to convey this information, and we're asking for help with the legal costs of hiring an appellate attorney. We found attorneys that are available and willing to help with this case. However, the cost is high and very challenging for myself, my family, and our collective resources. So we're asking for help. In discussing the case with potential appellate attorneys, there is hope that besides the perjury elements, there's another appealable issue that I have in my brief that on its own may be strong enough reversible error to obtain a new trial in our case. So there is hope. So please consider helping and informing more people you know who might be interested in helping. I've included the link to a website containing more information about what happened to our mom. On there is also a link for how you can help. Thank you.